Bryan Kohberger, the man convicted of killing 4 University of Idaho college students, entering a new request to withdraw his guilty plea, claiming he was misled by his legal team.
Are you pleading guilty because you are guilty?
Yes.
In a petition to the court, Kohberger now says he was convinced to falsely confess to the murders and that his lawyers advised him to lie to avoid the death penalty. Kohberger is currently serving 4 consecutive life sentences with no possibility of parole.
This is not uncommon for this type of buyer's remorse. And some guy hands you a plate of cream of chicken over toast and says, welcome to the rest of your life. And then they start to sit in that cell and say, well, God, maybe I should have taken a spin at this.
Kohberger's DNA was found on a knife sheath found at the scene, and investigators say his cell phone pinged a nearby tower at least a dozen times before the killings, and again the morning after. Prosecutors believed it was a slam dunk case.
They have records that he bought the type of knife used to kill these students. The evidence is overwhelming.
The family of Kaylee Goncalves, one of the victims, said they wanted the death penalty, writing in a statement, quote, Bryan Kohberger received exactly what he asked for, a deal that spared his life. Know this, he hates that life. He wants another chance to roll the dice. Kohberger says he's prepared to challenge the case on his own, but asked the court to appoint a lawyer to help him moving forward.
This risky move could put the death penalty sentence back into play. And if that sentence alone sounds almost unbelievable, wait until you hear how far he is actually taking this. A little over a year ago in a Boise courtroom, a judge looked directly at Bryan Kohberger and asked him one simple, direct question. Are you pleading guilty because you are guilty? Kohberger said yes. He said he had not been coerced. He accepted 4 consecutive life sentences without parole, specifically to avoid execution for murdering 4 University of Idaho students in their beds. Now he says all of that was a lie, not the murders, his own guilty plea. He is calling his own sworn admission the product of false promises and disinformation. He now claims he is innocent, and in a stunning twist that even seasoned legal analysts are struggling to explain, he has told reporters he welcomes prosecutors to seek his execution again, if that is what it takes to reopen this case. By the end of this video, you will understand exactly what Kohberger is now claiming, why legal experts say this attempt is almost certainly doomed to fail, and why, if it somehow does succeed, the consequences could be far more severe than anything he is currently serving. Before we go further, if you are new here, this channel breaks down real documented cases using real sources, no speculation dressed up as fact. Subscribe to True Crime Revealed so you do not miss where this case goes next. Let us go back to the beginning, because to understand just how significant this new filing actually is, you need to understand exactly what Bryan Kohberger already admitted to, under oath, in open court, and exactly what he gave up in order to avoid execution. In the early morning hours of November 13, 2022, 4 University of Idaho students were murdered inside a rental home near campus in Moscow, Idaho. Kaylee Goncalves, Madison Mogen, Xana Kernodle, and Ethan Chapin were all killed in an attack that shocked the small college community and quickly became one of the most closely followed criminal cases in the entire country. Investigators built their case around forensic evidence, including DNA connected to a knife sheath left at the scene, reportedly matching a single male source. Prosecutors also pointed to purchase records showing Kohberger had bought the same model of knife and matching sheath online. Kohberger, a former criminal justice doctoral student, was arrested roughly 6 weeks after the murders, at his parents' home in Pennsylvania. A grand jury formally indicted him in May of 2023, and prosecutors soon announced their intention to pursue the death penalty, citing what they described as the heinous nature of the crimes. For roughly 2 years afterward, Kohberger's defense team, 4 court-appointed attorneys led by Ann Taylor, one of the state's most experienced and respected capital defense attorneys, with nearly 3 decades of experience, more than half of it specifically focused on death penalty cases, fought aggressively to keep him off death row. Over the course of numerous hearings, they challenged the legitimacy of the DNA evidence connecting him to the scene. They argued that Kohberger's autism diagnosis should reduce his legal culpability for the crimes. They suggested there might be an entirely different, unidentified suspect who had not yet been found. They even argued that the death penalty itself violates international standards of human decency. None of these arguments succeeded in getting capital punishment removed from consideration through the court's own rulings. With his trial just a month away, Kohberger's legal team instead pursued a different path entirely, negotiating a plea agreement directly with prosecutors. On July 2, 2025, in an Ada County courtroom in Boise, Kohberger formally entered that plea. He pleaded guilty to 4 counts of first-degree murder, 1 for each victim, along with 1 count of felony burglary. In exchange, prosecutors agreed to take the death penalty off the table entirely. Judge Stephen Hippler presided over the hearing, and before accepting the plea, he asked those in attendance to avoid any outbursts or demonstrations during the proceeding. Hippler made clear the court was not strictly bound to follow the specific sentencing terms of the plea agreement and could theoretically impose a different sentence, though Kohberger himself would have no ability to challenge whatever sentence the court ultimately handed down. Crucially, as part of accepting this deal, Kohberger also agreed to waive his right to appeal his conviction. Then came the moment that now sits at the very center of everything happening in this case 1 year later. Judge Hippler asked Kohberger directly whether he understood he had not been coerced into accepting this agreement. Kohberger confirmed that he had not been, and then Hippler asked him the single most direct, unambiguous question a court can ask in a moment like this: are you pleading guilty because you are guilty? Kohberger's answer, on the record, in open court, with his own parents present in the gallery, was simply yes. This was not some quiet, quickly signed paperwork process happening behind closed doors. This was a formal, deliberate legal proceeding, specifically designed with built-in safeguards to ensure a defendant genuinely understands and voluntarily accepts the consequences of what they are agreeing to. According to later reporting, Kohberger was asked variations of these same essential questions more than once. First, through a lengthy, 9-page legal document that he personally filled out, initialed and signed, and then again through Judge Hippler's own direct questioning in court. This layered process exists precisely to prevent exactly the kind of claim Kohberger is now making, that his plea was somehow not fully voluntary or knowingly given. Sentencing followed on July 23, 2025. Kohberger received 4 consecutive life sentences without the possibility of parole, 1 for each of his 4 murder victims, along with an additional 10-year sentence connected to the burglary charge. Consecutive sentences, rather than concurrent ones, meant these terms would stack one after another, ensuring there would be no realistic scenario under which Kohberger could ever be released. With the death penalty formally removed from consideration and an ironclad set of consecutive life sentences locked in, this case appeared, to nearly everyone following it, to finally be over. That brings us to now, just over 1 year after that plea was entered. On Monday, July 27th, according to multiple outlets including the Associated Press, Kohberger filed a handwritten petition from the Idaho Maximum Security Penitentiary, where he continues serving his sentence. In this petition, he is asking the court to let him withdraw his guilty plea entirely and proceed to an actual trial. Let us walk through exactly what he is claiming, because the specifics here matter enormously. According to his petition, Kohberger argues that his original guilty plea was not knowingly or voluntarily entered. He claims his attorneys did not adequately represent him during the plea process. Specifically, he alleges his plea was, in his own words, induced by unkept promises and threats. According to reporting on the filing, he elaborated only briefly on these claims, suggesting his attorneys failed to properly disclose or review certain evidence with him, and that they manipulated him into accepting the deal partly by promising better prison conditions in exchange for pleading guilty, and partly by frightening him with descriptions of what life would actually be like on death row while awaiting execution. In a separate interview with the New York Times, Kohberger went even further, using language that represents an almost complete reversal from everything he told Judge Hippler under oath just 1 year earlier. He described his prior guilty plea as having resulted from what he called false promises and blatant disinformation. He told the paper directly, "My actual innocence is my truth," and insisted that his plea, in his own words, must be withdrawn. Now here is the detail that has genuinely stunned legal commentators covering this story, arguably more than anything else in this entire filing. Kohberger did not simply ask to withdraw his plea while hoping to avoid the most severe possible consequences. According to his statement to the New York Times, he explicitly told reporters that he welcomes prosecutors seeking the death penalty against him again, if that is what reopening this case ultimately requires. Think about what that actually means. A man who fought, through 2 years of legal challenges and an eventual negotiated plea deal, specifically to keep execution off the table, is now voluntarily inviting prosecutors to put it right back on. That is either a sign of genuine, deeply held conviction in his own claimed innocence, or an extraordinarily high-stakes legal gamble, depending entirely on which version of events, his sworn courtroom admission or his current claim, actually reflects the truth. It is worth pausing here to note the reaction from Kohberger's own defense team, specifically attorney Ann Taylor. When reporters contacted her office following news of this filing, whoever answered the phone immediately responded with, quote, "No comment," and ended the call before reporters could even clarify whether that response applied specifically to this new petition or to some other unrelated matter. That kind of immediate, reflexive no comment, without even confirming what question was actually being answered, suggests, at minimum, that this filing has placed Kohberger's own legal team in an extremely delicate position, one they are clearly not prepared to discuss publicly at this stage. So, how likely is Kohberger to actually succeed in withdrawing an already accepted guilty plea? According to legal analysis from multiple sources covering this filing, the honest answer is, not very. Courts generally set an intentionally high bar for allowing a defendant to withdraw a guilty plea after it has already been formally accepted, and for good reason. The entire plea process exists specifically to create a clear, well-documented, difficult-to-challenge record of a defendant's voluntary decision, exactly the kind of layered safeguards, the written questionnaire, the direct in-court questioning, that Kohberger's own case included. In order to succeed, a defendant generally must convince a judge either that their plea was genuinely entered involuntarily or that some other serious constitutional error occurred during the process. Multiple legal experts covering this story have described Kohberger's specific attempt as extremely unlikely to succeed, given both the strength of the original plea safeguards and the extensive, well-documented record showing Kohberger's direct, affirmative confirmation on multiple separate occasions that he understood exactly what he was agreeing to. There is also a specific procedural detail worth understanding here, because it sheds light on the timing of this filing. Under Idaho law, a defendant seeking post-conviction relief generally must file within 1 year after the 42-day window to file a direct appeal has expired. In Kohberger's case, that overall deadline reportedly falls in the first week of September 2026. His decision to file this petition now, roughly 1 year after his original plea, places this filing close to the edge of that legal window, suggesting this may represent something close to a final, last available opportunity to raise these specific claims through this particular legal avenue, rather than an early, easily repeatable first attempt. Now let us talk about what actually happens if, against significant odds, Kohberger's petition somehow succeeds, because the potential consequences here are genuinely severe, and arguably far more serious than most people considering this story would initially assume. According to legal analysis from the Isaacs law firm, successfully withdrawing this plea would not simply reset the case back to a neutral starting point. It could directly restore the possibility of the death penalty at the state level, the exact outcome his original plea deal was specifically designed to prevent. But the analysis goes even further than that. It suggests this move could also potentially expose Kohberger to an entirely separate federal case, one in which capital punishment would once again be a possible outcome, running alongside whatever happens at the state level. In other words, reopening this case does not simply return Kohberger to the legal position he was in before his plea deal. It could realistically expose him to 2 separate paths toward execution, rather than the single state-level threat his original deal eliminated entirely. It is also worth noting that if this petition were somehow granted and a new trial did move forward, it would not proceed under the exact same conditions as the trial Kohberger originally avoided. Since his guilty plea and sentencing, additional information from the original police investigation has reportedly become public, information that was not necessarily part of the public record before his plea was entered. Legal analysts have pointed out that it remains genuinely unclear exactly how this additional information, along with the significant amount of national attention this case has received in the time since, might affect how any potential new trial would actually unfold, adding yet another layer of uncertainty on top of an already historically unlikely legal maneuver. Stepping back, it is worth being completely clear about what this filing represents, and what it does not represent. This is not new evidence proving Kohberger's innocence. It is not a court ruling of any kind. It is a formal legal request, submitted personally, by hand, from prison, asking a court to set aside a plea that was entered with extensive documented safeguards, specifically designed to prevent exactly this kind of later reversal. A judge will now have to evaluate Kohberger's specific claims, that his attorneys manipulated him, that his plea was involuntary, against an extensive court record showing his own direct, repeated, sworn confirmation that he understood precisely what he was agreeing to, and that he was pleading guilty because, in his own words at the time, he actually was. There is also something worth acknowledging honestly here, a genuine tension in how to think about a case like this. Our justice system exists, in part, specifically to allow defendants meaningful avenues to challenge their convictions, including plea agreements, if genuine constitutional violations or coercion actually occurred. That principle matters, and it matters regardless of how disturbing or serious the underlying crimes might be. At the same time, plea agreements, particularly ones involving this level of documented deliberation, written questionnaires, direct courtroom questioning, and explicit trade of the death penalty for a guaranteed sentence, exist precisely to provide finality, both for the legal system and, just as importantly, for the families of victims who have already endured an investigation, an arrest, years of legal proceedings, a plea hearing, and a sentencing, believing, reasonably, that this specific chapter of their unimaginable loss had finally reached its conclusion. That is ultimately the piece of this story that deserves to be remembered most clearly, underneath all of the legal maneuvering and procedural complexity. Kaylee Goncalves, Madison Mogen, Xana Kernodle, and Ethan Chapin were murdered in November of 2022. Their families sat through years of pretrial hearings, watched multiple defense strategies fail in court, and eventually witnessed Kohberger himself stand before a judge and confirm, directly and under oath, that he was pleading guilty because he was, in fact, guilty. Whatever ultimately happens with this new petition, whether it is denied quickly, as most legal analysts currently expect, or somehow succeeds in reopening a case many believed was permanently closed, these four families are now being forced to confront the very real possibility that this legal process, one they had every reason to believe was finally, completely finished, may not actually be over after all. We will continue following this case as the court reviews Kohberger's petition, as any hearing dates are scheduled, and as this legal process, now genuinely uncertain in ways it was not just weeks ago, continues to unfold. We will bring you those developments the moment they are verified, and not before. That is everything we have for you on this update. If you want to understand exactly how this extraordinary legal gamble plays out, make sure you are subscribed to True Crime Revealed so you do not miss what comes next. Drop a like if you think the courts should hold Kohberger to what he already confirmed under oath, and let us know in the comments whether you believe this petition has any real chance of succeeding. Thank you for watching, and we will see you in the next update.